Hello guys, welcome back to Tinedu Children Law Update family. Thank you all so much for pulling up and supporting this channel. You're all amazing. In this video, we're going to review what is arguably the most significant and high-profile appellate decision in 2026 regarding the instruction of experts in children proceedings. This was a decision of the Court of Appeal Civil Division before the President, as it then was, of the Family Division, Sir Andrew McFarlane, Lord Justice Lewison, and Lord Justice Peter Jackson. The brief facts of the case centers on the regulatory and professional boundaries of expert witness in care proceedings. A mother appealed a care order on the basis that the court-appointed expert, an educational psychologist, had inappropriately crossed over boundaries to perform a clinical psychological assessment of her. Furthermore, a pending regulatory complaint regarding the expert's qualification was not fully transparently handled during the initial instruction of the expert and was not brought to the attention of the trial judge. We're now going to briefly go into the fact of the case, and you will see the reason why. On 19 February 2026, the Court of Appeal heard an appeal from care orders that were made in relation to 3 children by Her Honour Judge Gillespie in March 2023. The appellant, the children's mother, argued before the Court of Appeal that a jointly instructed expert psychologist, upon whose evidence the trial judge relied, had been acting outside the limits of his expertise, and that the orders therefore cannot stand. No other complaint was made about the judge's decision. In November 2025, permission to appeal out of time was granted on the basis that there was a compelling reason for the appeal to be heard, so that guidance could be given on the procedure to be adopted in similar circumstances. To prevent the children being unnecessarily disrupted or disturbed, a condition was imposed under CBR 52.18 that the children were not to be told of the appeal. The care order proceedings began in February 2022. At the outset, the court approved the instruction of Mr. Graham Flatman to provide a psychological assessment of the mother. He carried out interviews in May 2022, reported in June 2022, and gave evidence at the final hearing in March 2023. When accepting instructions, Mr. Flatman, the psychologist, disclosed that he was facing a tribunal hearing following a complaint to Health and Care Professions Council, otherwise known as HCPC. That complaint had been initiated by a parent in another family matter, but regrettably, this disclosure was not brought to the attention of the parent or the court. That complaint arose from unrelated proceedings in 2018. It alleged that Mr. Flatman had accepted instruction under an order that had referred to him as a clinical psychologist, and that he had conducted a clinical psychological assessment and psychometric testing of the parent when he was not registered and or qualified to do so. In October 2023, the complaint was upheld by the Conduct and Competence Committee of the HCPC, after which Mr. Flatman decided he would not undertake further work as an expert witness. In April 2024, the panel found that the proven allegations amounted to misconduct and imposed a suspension of 6 months upon him. In May 2024, the mother, in the case before the Court of Appeal, complained to the HCPC that Mr. Flatman had not been qualified to assess her and that his opinions had resulted in the care orders being made. It was not until September 2025 that she applied to the Court of Appeal for permission to appeal and for an extension of time for appealing. The appeal was dismissed by the Court of Appeal, and the court gave guidance for future cases in a similar situation. A party who seeks to bring a challenge of this kind in children proceedings should normally do so by making an application to the family court rather than by seeking to appeal. In addition to dismissing the mother's appeal, the court set down 14 pivotal guidance for family law practitioners on the exact approach to take when instructing an expert in care proceedings, and they include the following. Number one, the court must know about the expert's qualifications and experience before they get anywhere near the witness box. At the same time, it should not be forgotten that the boundaries of expertise of a subject matter are not always clear-cut, that there will always remain a role for judgment in relation to the instruction of experts and the assessment of their evidence. Number two, the detailed statutory code controlling the appointment of experts in children proceedings is to be found in Section 13 of the Children and Families Act 2014, also known as the 2014 Act, and also Part 25 of the Family Procedure Rules. Its purpose is to ensure that expert evidence is only admitted where the court has decided that it is necessary and that it is obtained from suitable expert in a focused and efficient way. When permission is granted, Rule 25.8 provides that it would only be in relation to the named expert. Section 13, subsection 2 reinforces this objective by providing that expert evidence obtained without the permission of the court will be inadmissible unless the court rules it admissible. Number three, the courts have a duty to actively manage cases, including controlling the use of expert evidence. That's in Rule 1.4, subsection 2E. Number four, permission must be applied as soon as possible, and that's found in Rule 25.6. Number five, an application notice must be filed unless the court dispenses with the requirement. This is found in Rule 18.4. We turn to number 6. Among other things, the application notice must state the field in which the expert evidence is required, Where practicable, the name of the proposed expert, the issues to which the expert evidence is to relate, and the questions that the expert is to be required to answer. And it must be accompanied by a draft order setting out a number of specified matters. These are set out in Rule 25.7 and Practice Direction 25C, 3.10, and 3.11. We turn to number 7. The matter specified Practice Direction 25C, 3.10 for inclusion in the application include the discipline, qualifications, and expertise of the expert by way of CV where possible. Number 8. The matter specified by Practice Direction 25C 3.11 for inclusion in the draft order include A. The issues, the proceedings to which the expert evidence is to relate and which the court is to identify. B. The questions relating to the issues in the case which the expert is to answer and which the court is to approve, ensuring that they are 1. Within the ambit of the expert's evidence, and 2. They do not contain unnecessary or irrelevant detail, and thirdly, are kept to a manageable number and are clear, focused, and direct. We now turn to the 9 pivotal guidance. The expert witness in children proceedings is subject to the duties set out in Practice Direction 25B, which includes the duty to comply with the standards for expert witness in children proceedings in the family court, which appears at the annex. The duty to confine the opinion to matters material to the issues in the case and in relation only to the questions that are within the expert's expertise or within the expert's skill and experience. And where a question has been put which falls outside of the expert's expertise, to state this at the earliest opportunity. These are set out in Practice Direction 25B 4.1, subsection A, E, and F. But on to pivotal point number 10. The annex standards require expert witnesses in children proceedings to comply with 11 standards, and they include the expert's area of competence is appropriate to the issues upon which the court has identified that an opinion is required, and relevant experience is evidenced in their CV. The expert has been active in the area of work or practice as a practitioner or an academic who is subject to peer appraisal, has sufficient experience of the issues relevant to the instant case, and is familiar with the breadth of current practice or opinion. If the expert's current professional practice is regulated by a UK statutory body, they are in possession of a current license to practice or equivalent, and these statutory bodies have set out this title in the HCPC. The entries include table of 16 professions that is regulated by them, and they are protected titles for each profession. Here we're going to be only concerned with practitioner psychologists. Number 11. The protected psychologist titles in the HCPC include practitioner psychologist, registered psychologist, clinical psychologist, counseling psychologist, educational psychologist, forensic psychologist, health psychologist, occupational psychologist, sports and exercise psychologist. We turn to pivotal point number 12. There is no legal requirement for a person describing themselves as a psychologist to be registered or to be a member of a particular organization. However, statutory regulation for psychology in the UK was introduced in the year 2009, and the HCPC is the regulator of practitioner or registered psychologist. Practitioner psychologists who have the qualifications necessary are registered with one or more of the 7 protected titles. In addition, there are 2 generic titles: practitioner psychologists and registered psychologists. These are available to registrants, to psychologists who already hold one of the 7 specialist titles mentioned earlier. Use of any of these 9 titles is legally protected. Number 13, pivotal point. The 2023 FJC and BPS guidance recommends that to assist the family court, all statutorily registered practitioner psychologists should use their protected specialist title as it appears on the HCPC register. Number 14. The 2023 FJC and BPS guidance also contains a useful checklist for instructing solicitors instructing a psychologist to ensure that the witness's regulator's status and protected title and up-to-date competence is understood. Pivotal point number 15. The court endorsed the decision made on 20 February 2026 in the case of REY, open brackets, experts on alienating behavior, the modern approach, close brackets, reported in 2026 EWFC from page 38. That's England and Wales. From page 38. EWFC from page 38. The President returned to the issue of unregulated expert and alienating behavior. Pending the outcome of a consultation being undertaken by the Family Procedural Rules Committee, he gave firm guidance that in the future permission should not be given under Children and Families Act 2014, Section 13, for the instruction of an expert psychologist who is neither registered by a relevant statutory body nor chartered by the PBS. It would be good practice before a potential expert is appointed for them to be asked to state whether they hold an HCPC protected title, and if so, what that is, before any order is made appointing them as an expert. The registered or chartered requirement should only be departed from where there are clear reasons for doing so. For example, where there is no registered or chartered expert or is not reasonably available, and where that is so, in other words, in which case those reasons should be set out in a short court judgment. And for some of us who may want to read the full judgment, the citation of the case is Re-Age, open brackets, children, expertise of witnesses, close bracket, reported in the year 2026, England and Wales Court of Appeal, Civil, from page 249. I hope you have found useful our discussion today. Please click, share, and subscribe, and provide your comment on your experience of instructing experts in care proceedings and the frustration you have faced in trying to comply with some of these provisions. Please share this video with others, including your legal colleagues, social workers, and other professionals. Thank you.